Miami-Dade County against the Department of Community Affairs, State of Florida.
Good morning. May it please the Court. Dennis Kerbel, representing Miami-Dade County. And I'd like to reserve 3 minutes for rebuttal, please. This case is about local discretion over local legislative planning issues. The Administration Commission violated the law by acting as a super planning board over Miami-Dade County. The specific legal issue here is whether the plan amendment is internally consistent with the county's comprehensive plan. As such,
is that the legal issue on the question of need, or is it simply whether the finding is supported by competent substantial evidence?
Your Honor, the question of need is completely tied up in the legal standard because, excuse me, because need is defined only by the county's own comprehensive plan. There is no definitive statutory standard that establishes what need is. The statute and the rules simply say the county's comprehensive plan must assess these matters and must come to some analysis of what the county's needs are. In this case, the county's needs analysis, or the needs requirements, are set forth in Policy LU-8F of the comprehensive plan. And the only place where that policy has any kind of quantifiable needs analysis or needs requirement is when it comes to residential development. And that, under 8F, the residential standard is to accommodate the projected population for the next 10 years, plus a 5-year surplus. But there is no numerical standard or definitive standard in the county's comp plan or in any other statute or regulation that defines need for commercial property. So in this case...
So even though there's no numerical standard, it's still a fact finding, isn't it?
Not exactly, because what the Administration Commission and the ALJ below them was required to apply was the fairly debatable standard. Since we are talking about a matter of internal consistency,
I'm not sure we are. I'm not ready to concede that. I realize it's not a fair fight, but the statute provides 2 different standards. The first standard is preponderance of the evidence as to whether a proposed plan amendment or plan is not in compliance. The second is fairly debatable. Now, I'm not sure we're over that bridge yet, to tell you the truth. I want to let you know what I'm thinking.
And Your Honor, that's actually where I was heading. What the statute says, this is under 3184 sub 10, is the county's determination as to matters of internal consistency is reviewed under the fairly debatable standard. Matters of consistency or compliance with the statutes and regulations are reviewed under the preponderance of the evidence.
It actually says whether the elements of the plan are related to and consistent, which sounds like consistency language. I agree.
Yes,
My problem is what Judge Clark alluded to also, is whether this finding, which quite honestly I think is central to the case of need, is simply a consistency finding or whether it's a finding subject to proof by preponderance of the evidence.
And as our position is that it is not a preponderance of the evidence standard because the only place where there is a need standard, anything resembling a need standard, is in the county's plan. The department likes to refer to a needs analysis and certain requirements, and planners employ certain methodologies and tools to analyze what they consider to be need. But the actual legal standard for purposes of consistency and compliance is the one set forth in the county's own plan. And when it comes to matters of consistency with the county's own plan, that is where the ALJ was required to apply the fairly debatable standard. So in other words, the question is whether the plan amendment to expand the urban development boundary into the urban expansion area was internally consistent with the county's plan turns on whether it satisfies first the policy 8F for non-residential land. And in this case, the county's standard is that non-residential development, particularly when it comes to neighborhood or community-serving business and office uses, and that's the key category here, community-serving business and office uses, are to be analyzed on the basis of localized sub-area geography. That's the county standard for need. which put into plain language is you have to plan for the needs of the residential community close to the residential community. And the reason that we've put this map up here is to show you what the community actually looks like. And if you see the subject properties highlighted in a little pink box, everything to the east of it and everything to the south of it is completely developed residential community. And what the comprehensive plan, what the county's plan says is, you are supposed to provide certain community serving business and office uses. Retail could be like a Publix or a home improvement store. You are supposed to provide those within close proximity to the residential community because as a matter of good planning, you don't want people driving everywhere if they don't have to get the stuff.
Well, doesn't a lot of that depend on the definition of what community-oriented means?
I'm sorry, Your Honor, I missed the question.
So doesn't a lot of that depend on what the definition of the community-oriented means?
Well, the definition of community-oriented, although it's not specifically defined in the comprehensive plan, is actually pretty well understood in the planning literature, and county staff and the experts that testified in support of the county amendment actually agree.
Well, county staff didn't testify in support of the plan amendment. They testified against the plan amendment, which was and once adopted by the commission, was ultimately vetoed by the mayor. And I'm wondering how that figures into your case about the county exercising its legislative prerogative and all this deference.
Because when it comes to planning matters, it is the county commission that ultimately
in a political decision which was made after the considerable resources of a fine commercial establishment were brought to bear on a political body, right?
Your Honor, respectfully,
let's cut to the chase. The county was not in favor of extending the urban development boundary at the planning level.
Well, Your Honor, I think that's where the ALJ and the Administration Commission made an error in saying that county staff is the equivalent of the county. The county, for planning purposes, is the Board of County Commissioners.
I'll grant you that.
As the legislature. And they made the decision not once but twice because they overrode the veto. And it's also worth mentioning that the elected officials for the immediate local area, the community council, were in favor of this amendment. So there is deference because this is a legislative matter.
I'm not sure whether it's your first point or second point, but this fairly debatable thing which you raise and which Lowe's raises also. What's the remedy that you seek from this court?
We seek an order explaining, finding that the order below failed to provide the appropriate deference. In doing so, they failed to actually apply the explicit policies in the comprehensive plan. And in order, in fact, consistent with the Catharines Bay decision, instructing them to find the amendment in compliance and to restore the county's ordinance.
You seek a win in this court. You don't seek a remand for application of the correct standard by the administrative law judge.
That's correct, Your Honor.
And in fact, don't we give deference to the Administration Commission, especially in a situation like this where it's so complex and it's so technical? Well, and don't we give deference to the Administration Commission?
Under normal circumstances, if it's a matter of fact, you would give deference, but this is a legal matter in which you are not obligated to give deference.
So you're saying the need for the facility is a legal matter, not a factual matter?
No, I'm saying, Your Honor, that the standard that applies to figure out whether there is a need for facility is a legal question. It's a legal question. It's purely a matter of what is written in the county's comprehensive plan. This court doesn't have to get into the details of the needs analyses and the different methodologies because under the fairly debatable standard, it's actually a fairly simple proposition for this court.
If it applies.
Yes, Your Honor, if it applies.
Which is interesting because some of the cases that you all cite, particularly the B&H travel case out of this court, are under subsection 9 and not under subsection 10. And subsection 9, as you know, is where the DCA agrees, where the state planning gurus, which is a nice way of characterizing the agency, when they agree with the proposed plan amendment. Sub 10 has two different standards, and that's what I'm trying to get you to talk about. Fairly debatable is one, but the other is preponderance of the evidence.
And again, I agree, Your Honor, and I'm not trying to dock that.
No, but they're the 800-pound gorilla by questioning your plan, or all counties in the state now in the amendment stage. By questioning your amendment, they trigger a different standard, which I would suggest, hypothetically at least, is not as deferential.
And Your Honor is correct about that. The reason that I keep going back to the fairly debatable standard is because the ALJ did not make any independent findings based on statutes or regulations or the state comp plan. What he did was he found entirely under the analysis of whether it's consistent with the county's policies, 8F and 8G. That was the entirety of his ruling, and everything else flowed from that. So he made no independent findings that it violated the statute. All he said is, for the reasons set forth, because we find that there is no need, therefore it violates Rule 9J5. But it's complete bootstrapping. If the county defines the need, and as the local legislature, it is entitled to do so by Chapter 163, the county defines what need is. And so if it's a matter of the county's consistency with the county's own plan, then that is entitled to the deferential standard of review. And simply what that means is there was evidence presented before the county commission that showed a need for more commercial land in this area to serve these communities. What was missing from the department's analysis, county staff's own analysis, and the ALJ's analysis was this matter of parcel size. They simply count up the vacant acreage and say you got 2 acres here, you got 2 acres there. All of a sudden, when they aggregate it and they add it up, they come up with sufficient commercial land. But what the county's policy requires is an analysis of, is there enough land for community-serving community-serving business and office uses? And what the standard provides there is you need at least 10 acres, and it's usually 10 to, could be 30 or 40 acres to provide that kind of a local shopping center. Both sides agree on that.
But there was a conflict on whether or not there was a need for that facility.
And, Your Honor, that goes right to the fairly debatable standard. There was a conflict. What the ALJ did not find is that the evidence supporting the county's decision was professionally unacceptable. The only way that the ALJ, under the standard of review of the county's own internal consistency, was entitled to overturn it was if he found that there was no evidence that could possibly support it. Fairly debatable is equivalent to substantial competent evidence under the first-tier certiorari.
So under that view, I mean, again, I like to cut to the chase. Once you or they presented Lowe's experts, you had to win this case.
The ALJ
Once you put on evidence to support the county commission's decision, you had to win this case, in your view.
If the ALJ...
No matter if the
Yes or
ALJ
no.
found that that market study was not reasonable, that it wasn't based on anything reasonable, that it should be discarded, just because it's there, the ALJ had to believe it?
That's not what we're saying, Your Honor. What we're saying is he had to find that it was professionally unacceptable. He specifically did not. His order said, I'm specifically finding it less persuasive. Less persuasive is not a call, unfortunately, that he gets to make under the legislative deference that the county commission is entitled to. Once he found that it was less persuasive, that was when he erred. And then he also erred in refusing to apply the requirements under 8F that he analyzed community-serving residential, and he erred by not recognizing the urban expansion area. He said this is an inappropriate location. But the location was decided by...
But why would the ALJ have to accept it when he said, I believe, that some of the assumptions in the market study were not even reasonable, and they were biased toward finding the need for the Lowe's in that certain area?
He found some, but not all, and he did not reject it out of hand. And there was plenty of other evidence that supported the county commission's decision here that was methodologically correct. As I mentioned, as I alluded to the parcel size analysis, that was unrebutted. And so, yes, with that in the record, the ALJ was required to either find that that was not evidence and therefore strike it, and on that basis, under fairly debatable, he could overturn it, or he was required to affirm the county commission's legislative decision. And I'll reserve the remaining
But he can
time.
say, I look at this study, and this study is not reasonable, it's not professional, it doesn't even, the results are biased, but I have to accept that?
No, Your Honor. He could have said, I am rejecting this study, it is not evidence, it is not competent, it is not professional.
And couldn't he also say...
But he didn't say that.
But couldn't he also say, this study is unreasonable, it's biased, it's not based on good assumptions, it wasn't available to the public, and moreover, I find more persuasive evidence that there is no need for the commercial establishment, for the commercial land.
But, Your Honor, that's not what he found. What he found was, typically, we will not pass on the professional acceptability. We will simply find this less persuasive. That was the error. He was not allowed to do that. And I'll yield the balance of my time for a rebuttal. Thank you.
Good morning, members of the Court. I'm Richard Grosso from Fort Lauderdale, representing the appellees. With me at council table is Mr. David Jordan, an Assistant General Counsel at the Department of Community Affairs. They've had some turnover recently. He's new to the case. He has asked me to handle the load of the argument before the Court today.
Tell me who you represent, Mr. Grosso.
I'm sorry, Your Honor. I represent the appellees, 1,000 Friends of Florida, and the National Parks Conservation Association. On that question, let me first address the standing arguments that have been made. The county has actually argued we don't have standing to be here as an appellee to defend the case. I'll just address that briefly. The rule cited, which I know very well has been addressed a lot by this Court, is that one must have an adverse effect to invoke the appellate jurisdiction. To be an appellant, one must be adversely affected by an agency final order to bring the appeal as the appellant. That statute
and we don't even address the issue of standing if we find that the Administration Commission and the ALJ were correct in finding that there was no need for the facility. Is that right? For the land.
I think the answer to your question is yes. There were 3 issues raised only by my clients below, not by the Department, and which the appellants are arguing that should not have thus been considered. They were found as an independent basis beyond need for the finding of noncompliance. So I think the argument there is we shouldn't be here to be able to argue them. We also didn't have standing below they're arguing. So what they're asking the Court to say is that the issues of urban sprawl, inconsistency with the administrative rule, and inconsistency with the State Comprehensive Plan should have been off the table and should be off the table. I think that's the implication of their argument that we did not have standing below. So I'll just finish the standing here. The statute simply doesn't apply to appellees, and it's nonsensical. The idea would be then that an appellee would have to have been adversely affected by the ruling below. Obviously, if you won, you're not going to be adversely affected. That standard simply doesn't apply. There's no case that has ever remotely suggested that you have to have adverse effect standing to be an appellee to defend a case you won. I don't know that I need to spend any more time on that. Let me speak to the question of standing below. The administrative law judge's findings of fact and the conclusions of law were that both organizations had associational standing, that they had members who met standing in their own right because they lived within the county, a substantial number, the administrative law judge found. And he found that the organization submitted, the only other prerequisite to standing is that you have submitted comments during the plan amendment process. Those are the facts of this case.
Really, under 31A4, if you are in the county and you submit comments, you have standing.
Yes.
So, I mean, this is not an actual injury or going back to the old Agri-Code. This is simply a statutory standing. And I'm not trying to make your argument for you, but I guess what I'm saying is I don't understand their argument.
I think, in fairness, their argument is that associational standing should not be applicable under that statute. That's their argument. It's not correct at all.
Well, if that's the case, then I suppose no business would ever have it.
Associational standing has a long history, obviously, in the state.
What I thought of reading this case is that if Home Depot operated a store in Miami-Dade and they had challenged this, they would have had standing.
Yes, Your Honor. They've said associational standing is not explicitly called for under the statute. It's not explicitly called for under any statute.
That's the only
It's a judicial doctrine.
I understand.
NAACP has made it clear members don't have to participate. Home builders said you have standing if you represent people who themselves would have had standing. Those are the facts, Your Honors, of this case. The final case that the county argues is Florida League of Cities, which said an organization did not have standing to bring a rule challenge. But the standard there to bring a rule challenge is a substantial effect, is a substantially affected standard. Obviously, as Judge Kahn has just remarked, that's not the standard in these kinds of cases. So clearly there was standing. The second point I'll respond to is that as a completely second independent basis for standing, the final order found that 1,000 Friends of Florida did operate a business and had standing also for that purpose. The point I need to make is that this Court does not need to agree with that proposition in order for there to be standing, because associational standing applies completely and supports standing below.
The Administration Commission found both types, if you will.
Yes, Your Honor. And I acknowledge the St. Joe Paper Company case. I was the attorney of record in that case. I know what a difficult case it is. I think what you see here is in coastal development and in final orders in these cases below, you've got an agency that continues to try to suggest to the appellate courts that the kinds of things that are in fact impacted by comprehensive plans are pretty broad. They keep suggesting that business ought to be read perhaps more broadly than St. Joe did, but I need to make clear that standing does not depend on the business finding here. Let me speak now, if I may move on then, to the merits of this case. For the county to say you should reverse and find the amendment is in compliance, the county is saying to you, you must issue as a proposition of law the following statement, that biased, unreasonable data and analysis that are skewed to predetermine an outcome are, as a matter of law, professionally accepted under this act. That would have to be the ruling that this court makes to reverse and grant a victory to Lowe's and the county. And I would humbly submit that to look at the entire statutory scheme, let alone the detailed requirements about data and analysis, that simply cannot be what this law is. It cannot be that any study, any expert opinion put up is automatically must be accepted. There was a suggestion, I know, in one of the briefs below that the biased finding of fact that the law judge made was nothing other than it was biased because it was done by a consultant to Lowe's. Now, that was not the basis for that finding. The finding, as a matter of fact, was not challenged as being unsupported by competent substantial evidence, is based on significant amounts of competent substantial evidence. Just a few key points. The assumption of how much commercial development you could get on the vacant acres that were already allowed for commercial, the analysis assumed you could only get 1/5 the amount of intensity that the plan allowed. So it significantly underestimated, underprojected how much commercial development could go on the vacant parcels that were in the county. That's one set of evidence. The second is that it was a market study. The Growth Management Act is about what are this community's needs to serve its planning objectives. These analyses were market studies of profitability, whether the outfit believed it could make a go of it by putting the project there. Those are distinct things. And the growth management does introduce, it doesn't make market things completely irrelevant, but the idea here is that it's the county's needs, the local government's needs that predominate. It was a market study. It was not a needs analysis. The other point was that the county has adopted into its plan the geographic spatial scopes of the areas that it looks at. And these analyses were sort of self-defined by Lowe's. And just to take it to an absurd example, if I live on a residential street and there's no commercial, and you know, I want to change my land use to commercial. If I want to find there's a need for commercial, I'm going to define the geographic area as just my street. And there's only houses, there's not commercial. You can do things like that by gerrymandering a spatial scope of analysis. The county has adopted these specific minor statistical areas and tiers. They weren't used in these analyses. Those are some of that's some of the evidence that clearly supports the administrative law judge's factual determinations of bias and unreasonableness. The next point I want to make is that there's a legal requirement that the data be professionally accepted. There's a second independent requirement that even professionally accepted data and analysis be applied in a professionally accepted manner. The law just clearly finds this was not. You can have a good study, but if you're using it for the wrong reason, it violates the law. And that's another basis for the determination here. The third key point I want to make is that the Act specifically requires the consistent use of data and analysis. Yes, the local government does have some discretion to choose what professionally accepted methodology it's going to use to determine the planning facts. That is the law, and I'm not arguing otherwise. But what the law doesn't allow us to say, if, for example, your three honors were three separate applicants for a commercial development, we're going to use the county staff's methodology that we've adopted into our plan for Judges Kahn and Judge Padovano. But for Judge Clark, we're going to find there's no need. But now for Judge Clark, we're going to use a new study that Judge Clark's consultant has written up. And it uses a different methodology, different spatial areas, and all sorts of different assumptions. And we're going to adopt her analysis, and it says there is a need. So the facts for her case are there's a need. The facts for your applications are there isn't. You can't do that under this law. There's discretion to choose the methodology and how you're going to approach it, but it can't be I pick and choose for one applicant over the other. So again, let me be clear. We're not saying there's not discretion, but it has to be professionally accepted. It has to be used and applied consistently across the board. And you can't adopt methodologies on a case-by-case basis that are different than what you've written into your comprehensive plans in terms of the area you look at and the assumptions, like how much commercial can I get on the already vacant development. That's 5 times. That's a big difference by 5 times underrepresenting how much commercial development can be accommodated in the relevant study area. So I think clearly the appellants cannot overcome the findings of fact of biased and unreasonable and skewed to predetermine an outcome. There's more than adequate competent substantial evidence below to support those determinations. The next set of points that I want to speak to, Your Honor, is the urban sprawl determination. I think there's sort of a suggestion by the appellants that every basis for determining the amendment is out of compliance, every legal ruling is based on the fairly debatable burden of proof, and that there's been a sort of a suggestion that the only basis for finding the amendment to violate the law was that it was internally consistent with the county's own comprehensive plan. Now, that was a key issue. Surely it was. But over and above that, the administrative rule requirement that plan amendments discourage urban sprawl was violated. It's not an internal consistency thing. That's a matter of state law. The administrative law judge found by a preponderance of evidence that enough of the triggers of urban sprawl under the criteria of the rule were triggered that it failed, the amendment failed to discourage urban sprawl because it was an unnecessary intrusion into wetlands. It had a negative impact, not a huge one, but a negative impact on the county's key strategy of promoting infill and redevelopment so that most of the development in the county was occurring in the existing paved areas, in the existing developed areas. That these findings are based on competent substantial evidence. There's no basis to overturn them. The appellants are asking the court to reweigh and rebalance the factual findings, redo the balancing and weighing of the factors that are supposed to be considered so that this court is now going to make the factual determination as to whether the amendment constitutes urban sprawl or not. I want to make a point about the exhibit that we're looking at here. Yes, this parcel is adjacent to and nearby to urban development. That is how it is in Miami-Dade County. The urban development boundary in Dade County was written to arrest this problem that there had been significant amount of urban development encroaching into farms and remnant Everglades wetlands, which this parcel is. It is the nature of that beast that substantial areas of the lands, the farmlands and the wetlands outside of the boundary are going to be adjacent to urban development. That is just how it is. The county drew this line in the sand to say we can't allow that to happen as much anymore because it had adopted under this Growth Management Act that requires these things.
This is something that was argued in the briefs, but I haven't heard a comment on. What significance do you give to the county's prior designation of the urban expansion area?
Okay.
They argue they've already made this decision.
Yes, that's not accurate, Your Honor. I have to agree that the plan has said when you have to move the urban development boundary, the urban expansion area is the place you should go to. There is definitely that preference. That's clear.
But isn't that kind of silly in a metropolitan area that is completely 100% developed from the Atlantic Ocean west to wherever it stops? That's where they go. Of course, that's where they go.
Not all areas are designated as urban expansion, to be fair. Okay, so surely there are areas that aren't there, that aren't urban expansion area. The problem with this appeal is that the appellants are asking this court to read that preference when more lands are needed as an automatic pre-approval. They're arguing that the standards that one must meet to move the urban development boundary don't apply if you're in the urban expansion area. That was found to be clearly an unreasonable interpretation of those policies. That is absolutely not what they say, and that interpretation asserted here is surely not a fairly debatable proposition under this Act, Your Honor. I think I'm out of time now. I know some of the issues, there's a lot of similarity in issues to be dealt with in the next case.
So that'll be a very short argument.
I'm sorry?
That'll be a very short argument.
It will. Before I sit down, if there are any other questions, I thank you very much.
Thank you, Mr. Grosso. We have a short time for rebuttal.
Thank you, Your Honor. It cannot be urban sprawl to urbanize the previously designated urban expansion area. That's a ludicrous proposition, and not all of the area outside the county is the urban expansion area.
Well, their proposition is pretty straightforward. It's that if the other thresholds are met, that's where the boundaries are going to be expanded to. It's as simple as that. Why is that wrong?
That is correct, Your Honor. But the threshold question here is not, is it wetlands or is it ag? That's the part that I'm saying has already been decided. Locationally, that's the right place. The only question is one of timing. The ALJ obviously disagreed with the county's decision, but the data and analysis, and they have, the ALJ gave short shrift and did not recognize all of the studies that were in the record. It's not even clear.
Let me ask you how this works. Is this a horizon out to 2015? I'm not sure I got the date right.
The urban development boundary is 2015.
So,
the urban expansion area is 2025.
2025, okay. So at 2015, in any event, probably the county is going to do something with the urban development boundary.
No, not necessarily. Actually, it's a rolling line. So it may just roll over to 2025 at the next year. And the county has actually been very conservative in its land use, contrary to their suggestion. The population since 1988 has grown 25%. They've only expanded the urbanized area 7%. So I take exception to the suggestion that somehow this is unrestrained growth. It's actually very well planned growth. And in this case, yes, there's a residential community there. And the issue is, can we expand the line to serve that residential community? We're not adding new residents.
And I just keep going back to the ALJ's finding that there was no need for more commercial land in the area of the Lowe's site.
But precisely that analysis is where he was required to give deference, and at the very least, he needed to look at all of the various studies that were presented. He doesn't even specify which methodology or which study he considers biased. The parcel size analysis, the Torres report, as we refer to it in our brief, tracks county staff's analysis. It simply says you can't just take the scattered 2-acre parcels and say that's enough. He was, under the fairly debatable standard, required to look at that. And his refusal and his decision specifically to go on persuasion rather than on professional acceptability was legal error.
Your time's expired. If there is another case.